Friends, welcome to the second part of the module. In our inquiry under culpable homicide amounting to murder, we tried to understand the concepts of physical element and the fault element which was required for an inquiry for culpable homicide amounting to murder, and also the contemporaneity principles, that means the physical element and the mental element and the fault element must concur. Having done that, we move on to some of the fundamental principles which would be helpful for our inquiry, and that is causation and objective and subjective liability, and a brief introduction to culpable homicide. Now coming to causation first. Causation is an issue in result crimes. I hope you all know that, and I hope you know the difference between that they are result crimes and conduct crimes. But still, I would like to still reiterate that result crimes are those crimes where the offence has a result attached. So there should be a consequence. Okay, so the consequence is prohibited. So in case of murder, the killing, the death is the consequence. So that's a result crime, because your act results in a consequence. Whereas in the conduct crimes, the conduct itself is punishable. So you really don't have a problem of causation. Causation becomes the issue only in result crimes. Now, as far as my understanding of the Indian Penal Code and my study of the Indian cases been, I get a feeling that Indian courts deal with causation in a very silent manner, and that is why for ordinary readers, I am sure they deal with causation. Of course they deal with causation, and that is why they are able to give the results. But they do it sub silentio. We don't get a sort of a discussion around causation. Now you would understand and you would agree with me that every consequence is a result of many factors, but all factors may not be relevant for your scrutiny under criminal law. Now, which are the factors which are essential becomes a problem, becomes the issue in criminal law. You have to, establish the chain of causation. So the offender does an act, okay, and a consequence ensues. Now you would have to establish the chain of causation. So causation could be of two types: factual causation and imputable causation. See, factual causation, there is no problem, that's dependent on the facts. The problem is with imputable causation. Now, you shoot a person, he is going to the hospital, there is an accident in the way, he reaches the hospital, he dies. You would have to establish a causal connection. Was it the original act that was responsible for his death? Or was there novus actus intervenience? Was there a sort of a break in that causal connection? There was an accident. Did that cause your death, cause the death of the person who died? So to establish a causal connection is very, very essential. Just to give you a case, there was a case, Joginder Singh versus State of Punjab. What happened in this case was, this man was running, he was being chased, chasers was behind him, he was running, saw a well, he jumped into it. The question was, were the chasers responsible for his death? So obviously a causal connection had to be established. Causation was the issue. Did the people who were chasing him cause his death? So the court said it was not because of the people who were chasing him that he jumped into the well. So they were not like, he was not there, there was no other way. So there were other ways also for him to escape, and these people were held not responsible for his death. There's another very old case of 1912 which may again very clearly tell you causation. It's Emperor versus Surya Narayana Murthy. What happened in this case was that the defendant wanted to kill another person. So there was an intention to kill a person, gave him halwa and poisoned it with arsenic, offered it to him. Now this man, the intended victim, ate it, didn't like the taste. Arsenic was mixed and could maybe sense it, I don't know, but didn't like the taste, threw it away and walked off. So nothing happened to him. A girl, Raj Lakshmi, was going, she saw halwa, thrown away, and probably fond of halwa. She picked up the halwa, ate it, and she died. The question was, is the defendant responsible for the death of Raj Lakshmi? Could there be a causal connection between the physical element of this and the fault element with the consequence that happened, the result crime which happened? The court said yes. It found causation there. It said imputable causation has been established, and this man, the defendant, was held responsible for the death of Raj Lakshmi. So you must understand that the causation is a very tricky subject, and we must keep this in mind, and it is very important for us as criminal law students to engage with the principle of causation. Another very important principle that we must keep in mind is the objective liability and the subjective liability. Now, before I get into 299 and 300, whether objective liability is there or subjective liability is there, I want to take you back to Lord Macaulay, who drafted your Indian Penal Code. Now, Lord Macaulay was not happy with objective liability. He wanted a subjective liability. Please go through the debates. I don't have time for that. Now, just to give you an example, there was an English case, DPP versus Smith. It's a 1961 case. A police officer wants to stop somebody who's in a vehicle. This man wants to run away. The police is adamant about stopping. The police jumps on his vehicle. This man starts driving the vehicle very fast, right, left, to throw off the police officer. So his intention is to throw off the police officer. He manages to do so, but the police officer falls on the highway, and another vehicle coming over runs him over and he dies. The question was of liability for murder. The court said, as a reasonable person, this man ought to have known, should have known that this act of his, that physical element of his would cause death, and so he was held liable for the death of this person. Now, Lord Macaulay was not happy with the objective liability, because in English law, I gave you the DPP versus Smith case to tell you what is objective liability. But in English, in the common law, there was a principle called, there was a rule which was the felony murder rule. Now, what was the felony murder rule? It was that if a person was doing felony and in that he ended up murdering a person, he would be liable for murder of that person. I'm sorry, I used the word if he ended up murdering the person. I should have said if he ended up killing the person, he would be liable for murder. Murder is the highest form of killing, for which you could be culpable. So, culpability is of the highest level. So, if in doing a felony, you ended up killing a person, you would be guilty of murder. This was the felony murder rule. And Macaulay critiqued it. He said, if by pure misadventure, this man who's committing felony commits murder, commits killing, it doesn't, further your cause of human security by making him culpable for murder. So, this was Lord Macaulay. And that is why when he drafted the Indian Penal Code, he, as far as my reading is concerned, he wanted a subjective liability in the Indian Penal Code. And that is why, when friends, you read the sections, please keep this in mind, that this is what the idea of Lord Macaulay was. One, he wanted a very precise code. He didn't want any ambiguities. He wanted a clear, precise code. Plus, he was an advocate of a subjective liability. Now, let's discuss culpable homicide under section 299. So, 299 defines culpable homicide for us. Now, section 299, for my understanding and to make it easier for you, I have broken it into 3 parts. It doesn't have 3 parts, but I am breaking it into ABC. So if you look at it, it says whoever causes death by doing an act A with the intention of causing death, B, or with the intention of causing such bodily injury as is likely to cause death, C, or with the knowledge that he is likely by such act causes death, commits the offence of culpable homicide. So what I have done, friends, is that I have broken it down into ABC, and you would see that for culpable homicide, the fault element required is intention and knowledge. So these are the highest forms of fault elements which would be required. Now there are three explanations appended to your section 299. The first one says that if the victim is suffering from some infirmity or disease and you commit the death, it accelerates the death, then you shall be deemed to have caused his death. Now some commentators argue that this is akin to the thin skull principle of the common law. But for me personally speaking, the word accelerates death negates that sort of a claim. So what it says is, because again going back to my subjective liability, so at the back of my mind the subjective liability under which Macaulay worked is guiding me. So when I say accelerates death, it meant that you did an act, okay, but what the infirmity or the disease did, it accelerated the death, and in only that case you would be liable for causing the death of a person. The second explanation deals with that by resorting to skillful treatment, if death could have been prevented, still you would be liable for death. So the role of the doctor, the role of skillful treatment is considered de minimis. It's not considered intervening something which is breaking the chain. So it's a very, very de minimis thing that it is considered. Third explanation tells you at what point of time does the human being come into existence for an inquiry for culpable homicide. So it says within the womb, it cannot be counted, but if some part of the body comes out, then you come into existence for the offence of culpable homicide. So friends, I discussed the fundamental principle of causation which you would have to keep in mind. I discussed the objective and subjective liability. I discussed with you the definition of culpable homicide which is in section 299 and the explanations which are attached to section 299. Now we would move on to the third module where we would now graduate to discussing culpable homicide amounting to murder.